So today we are going to talk about the 7 deadly sins of estate planning. How many of you have attended one of our classes before? How many of you attended one of my classes before? Okay, so I will try not to reuse my jokes, but I don't have all that many, so sorry in advance. You don't remember, perfect. So I am pretty loud, I think, at least that's what my husband says, but if anyone in the back can't hear me, just holler or throw something at me. First, I'm just going to talk a little bit about our firm and introduce myself. We've been in Ridgewood for about 48 or 49 years. Used to be Michael Manna and Associates, it's now Manna Helmy Law Group. I have not been with Mike for 49 years. I'm not yet 49 years old. Proudly, but I have been with him for about 17 or 18 years. And this is really all we do. We are 4 attorneys, 5 paralegals, and all we do is elder law, estate planning, guardianships, wills and trusts, some real estate, and really the intersection of where family and money intersect. So this is really our niche. What I want to talk to you about are things that surprisingly are repeated issues that we see all the time. And the reason I say surprisingly is that we are in the information era. You could find anything online. Everyone knows why they're going to the doctor and what they've diagnosed themselves with before they get to the doctor's office. But for some reason, despite this wealth of information and everyone's fear-mongering, there are repeated mistakes that we see all the time. So I like teaching this class because I'm hoping to give you some piece of information that you don't know and that can hopefully prevent some issues for you in the future. Feel free to raise your hand. At the end of every little segment, I'll ask if you have any questions. Feel free to interrupt me and ask, although don't be offended if I ask you to hold your question until later on. It might be coming up. Just so I have an idea of where everyone's at, how many of you have wills? Oh, good. How many of you have power of attorney documents? Okay. And how many of you are here to learn something for yourselves versus a parent or a family member? Yourselves. Okay, good. Anyone here because they're concerned about their families and their parents? Okay, kind of both. All right. So I mean, this is good. This is a resourceful crowd. So somebody tell me, what is a power of attorney?
It gives you the ability to take care of somebody's financial matters, their business dealings, should they become incompetent or unable to handle them on their own.
Right. It's a document that allows someone to act on somebody else's behalf. Everybody over the age of 18, in theory, should have a power of attorney because they are no longer children of their parents and they need someone to be able to make decisions for them if they become incapacitated. If we don't have a power of attorney, what happens? Who knows? Anyone ever deal with a guardianship? Nobody. It is not easy. It is not cheap. It can become quite a hurdle. And that, unfortunately, is the only legal method to get access to somebody's affairs if they don't have a power of attorney and they are now incapacitated. First, I want to tell you there are different kinds of power of attorneys. There are financial power of attorneys and then medical power of attorneys. Some attorneys put all this in one document together. That's fine. I prefer not because the person who might be making your financial decisions may not be the person you want making your medical decisions. And one document is really used for banks and clerks and whatnot, depending on what you're doing. And the other is doctors and hospitals. So I think it makes sense to separate the two, but they can be one document. For purposes of this conversation, let's separate these things. In terms of a financial power of attorney that allows someone to act on your behalf, a lot of people think they don't need one because, well, one day I went to Chase with my daughter and the bank teller told me I could sign a form and that's a power of attorney. I can't tell you how many people come in and they say, oh no, we did all this already. And I say, can I have a copy? And it's a document that it names somebody as power of attorney for that specific account. That is not necessarily helpful, because it depends on what you want to do. But I can have a power of attorney with Chase for my specific account where I name my daughter as my power of attorney. That doesn't give her the right to file my tax returns or sell my house or, no, that's okay, or apply for some benefit on my behalf. Here you go, no problem. So that is very different than a general power of attorney. Okay? A general power of attorney should sound like, I give this person the authority to do these things on my behalf. And then you list what's in there. Now, another thing that sometimes surprises me is when somebody comes, no, I shouldn't say surprises me, it doesn't surprise me, but it's a shame because of, it is a common misconception. Somebody might come in and say, I didn't need a power of attorney because all my assets are joint. I don't need a power of attorney for my husband. Our assets are joint. My name is on his house. I can sell it. I shouldn't say his house, our house. My name is on our house. I can sell it without him if he's competent or not, right? Wrong. Now this is a tricky one. His name is not on the house. It was my house all along. It's a premarital asset, or I inherited it and I want to sell it. Can I sell it without him? No. He still has a marital interest in the property. I still cannot convey it without him or a power of attorney for him if he's incapacitated. It is one of the most overlooked documents and very important, so I'm happy that most of you have one. If we don't have one, what does a guardianship look like? I mean, I tell people this is something that nobody should be trying to get a guardianship unless it's really a last resort. If it's inevitable, then you may have to do it. But it's not, like I said, not cheap, not quick, not easy. Basically, we need somebody to petition the court and tell the court, Judge, I want you to declare this person incapacitated. Take away their rights to do X, Y, Z. Maybe you want them to be, you want guardianship over their person and their property. You say, take away this person's right to vote. Take away this person's right to manage their affairs. Take away this person's right to make medical decisions for them. And Judge, give it to me. Oh, and by the way, in case I want to do some medical, some planning to apply for government benefits to help pay for their care because presumably they are incapacitated, give me the right to take the assets out of their name and give it to myself too. Yeah, they love that. So what the court does to protect the alleged incapacitated person is appoint an independent attorney to represent them. I need 2 psychiatrists to prove, or a psychiatrist and a physician, to prove that this person is in fact incapacitated. Then I may need to be bonded and purchase a bond, an insurance policy, that I'm not going to take the money and run away. And then I need to provide an accounting to the court every single year, in some counties every 6 months, what I did with the person's money during that time. On average, you're probably talking $10,000, $15,000 right off the bat, beyond the annual expenses and bond premiums and all that, which will depend on how much the estate is worth. Again, all of that guardianship world can be avoided if you have a power of attorney. Very important. Any questions on that?
Who determines the incapacitation?
Oh, good question. The question is, who determines the incapacitation? Well, if I am drafting the documents and I hear that the person that the client trusts the person they are appointing, my recommendation is it's irrelevant. Why? Because if you trust this person, I would recommend you have a document that says it's effective immediately and despite their incapacity. Why? Because sometimes it's drafted to say this works only until they become incapacitated, or it's a springing power of attorney, which only becomes effective if they are incapacitated. And that's the million-dollar question that makes those documents hard to use. Who determines that incapacity? And if anyone's dealt with anyone with any cognitive issues, for example, you know there's 50 shades of gray, and one doctor might be saying, sure, this person's competent. One doctor may be saying no. The other may be saying, well, it depends on the time of day because they have sundowning. And these documents from the physicians, even if it's very conclusive, they don't last forever. So if I go to Bank of America and I say, I have a power of attorney that says I can act on this person's behalf if they're incapacitated, the legal department there is going to say, give me proof they're incapacitated. Now I give them a letter from a doctor that says, well, this person has some physical limitations, or this person has some cognitive impairment. They're going to say, that doesn't mean they are incapacitated, and then you're in guardianship world anyway, which defeated the whole purpose. Or you have a document that says this person is in a coma. They are undoubtedly incompetent. But I bring the bank the letter from a week ago. Well, are they still in a coma? Do you have authority to act on their behalf right now? So again, that becomes very expensive to use. Now, some clients come in and tell me, you want me to sign someone a power of attorney now while I'm healthy that gives them the right to act on my behalf now? And I say, yeah. They say, well, what if they do something wrong? What if they go do things behind my back? Now I say, well, if you're worried about them doing something behind your back when you're competent, they're going to be the first person to do something behind your back when you're not competent. So I think that's a total false sense of security and does nothing except complicate their lives and the logistical ability for them to use it. If we have doubts about the person acting, there's other ways to limit their power, or maybe we don't do one at all. But if we're okay with somebody acting on your behalf, but we're nervous, we may want to limit their powers either by specifically saying, well, they can do these things, but they can't gift. Or, well, they can do these things, but they can't do it unless they have the consent of somebody else. So there's a check and balance. There's other ways to limit. But that's a very good question. I'm glad you asked that. For myself, what I do for most of my clients, and even for myself, if I trust the people I'm appointing, I give unlimited power and it's effective immediately. However, I have the documents in my house. And I trust my husband, but what if the person we're naming as a backup is not so trustworthy, or maybe they are, but we just feel a little weird about giving them some authority to act on our behalf now when we're young and healthy. But that document's in my house. And every time I get on a plane with my husband, I message the person who's our backup and I say, just a reminder, this is how you get into our safe that's in our house, and here's the code, and that's how you get it. So at least if something happens, they can get access to it. If they don't have it, they can't use it. Good? Any questions about that? Thank you. That's a very good question. All right. Next, big mistake. Preparing these documents yourself. Okay, who knows what DIY is? What trendy, who goes on Instagram here? I'm a big DIY person. You do things yourself. I like doing things myself. I like, believe it or not, painting the walls in my house, although I usually get vetoed because, 2 weeks into the project, someone in my family is like, okay, you're done. This is a waste of time. But you can go on YouTube and figure out how to do anything yourself. So why not prepare these documents that are all over the internet on your own, or using something like LegalZoom or one of those things? Why not? Well, here's the issue. When are we using these documents? When are we using a power of attorney? When are we trying to use it? When somebody's incapacitated. Or if it's a will, when somebody's deceased. Now, what happens if we screwed it up? Person doesn't have the authority. There's a lot of good stuff online. There's also a lot of junk online. And it's hard to differentiate for the average layman the good from the junk until you're trying to use it, and then you find out all the problems. The problem is when you're trying to use it, it's probably too late to fix it. So my opinion is this is not the area where you want to go dabble in something yourself, especially when it could potentially govern everything you own. So not the thing we want to be, economical with, and you want to do it the right way. Number 3, common mistake, not having the right attorney draft your documents. How many of you, well, I shouldn't ask this question, but I'll just say this. Most people, the attorney that they've dealt with, the attorney that comes to mind, hopefully, in your lives, is a real estate attorney. For most people. You bought a house, you sold a house, you know a real estate attorney. If you call a real estate attorney and you say, can you prepare a power of attorney? Sure they can. Why? Because when they're going to do a closing, sometimes they're preparing a power of attorney. That document is usually for purposes of somebody going on your behalf to the closing. New Jersey is very quirky when it comes to power of attorneys. New Jersey courts have said that a power of attorney that even gives you the right to act on somebody's behalf by virtue of the language, I give you the authority to do anything and everything I could possibly give you the authority to do. Hello, that's okay. Is insufficient. I'm going to repeat that. Even verbiage that says, I give you the authority to do anything and everything I could possibly give you the authority to do, is insufficient to allow you to do certain things. There are certain powers that are called hot powers. They need to be specifically stated in your documents. If your documents say, was it Cecilia? Cecile, okay. I give you the right to do anything and everything on my behalf. Can she go and sell my house? Yes. Can she go gift my house? No. Can she set up a trust on my behalf? No. That language has to be specifically in there. Now, most attorneys don't do Medicaid applications. If an attorney does not do a Medicaid application, they may not know what things you might need to do for a Medicaid application. Some of those things are gifting and setting up trusts. For example, if I have a husband and wife come in, and husband and wife say, or let's say husband comes in and says, my wife had a stroke, I cannot lift her, how do I pay for her care? I'm not a veteran, I don't have long-term care insurance, what do I do? Well, we can move assets to you. Medicaid allows you to do certain things. There are certain loopholes and exceptions to the Medicaid rules. You can gift unlimited assets to a spouse. If the document doesn't allow that, the person can't do it. Now we're in guardianship world again. So I'll give you an example of this. I think it was 2014 or 2015, I was teaching a Parkinson's support group at Wayne Public Library. After the meeting, very nice gentleman and his wife came and said, okay, we get the point. We need to do a power of attorney for my wife. She's at home. She has Parkinson's. We did one a long time ago, but I don't know. You scared us. Can you look at it for us? Can we send it to you? Sure. Here's my email address. They said, and I asked them, is mom competent? Yeah. Oh yeah, she's fine. She just has the shakes and whatnot. Okay. They send me the document. It says, I give you the right to do anything and everything I could give you the right to do. Signed. Obviously, we know that's not enough. So I tell them that. They say, okay, what do we do? I say, well, she can sign a new one. Is she competent? Now, by this point, by the time it took them to get it to me, I don't know if she had declined or what, but they still said she was competent. So anyway, I said, bring her in. Let's figure this out. I meet with a woman, lovely woman, who thinks that she just had 9 kids with George Clooney. So clearly, Elvis has left the building. They say, well, what do we do now? And they said, well, you can do a guardianship, but, do you need one right now? Like, you only want to do that if you really need it. Do you need it? And they say, well, I don't know. I said, well, who's going to take care of her? What's going on with her? Well, she's staying home. They had 2 kids. Both kids lived at home. One had some psychological disability. He was never leaving the house. He's not going anywhere. He's staying home, and he can help take care of mom. Husband retired. He's taking care of mom. She's not going anywhere. I say, all right, well, if you never need it, then you never need it. Maybe one day she dies in her sleep and you never need it to do anything. So I wouldn't go do a guardianship for no reason. They said, okay, we're fine with that. I did tell them, though, if you do need it, it's going to be a time crunch. That's up to you. You got to gauge your bets. They didn't have all that much money. They couldn't afford doing a guardianship for no reason. So they didn't do it. A few years later, the husband calls me. The wife's in the hospital. She had a fall. She's become dead weight. He has knee issues now. He can't lift her. It's too much. It's not safe for her. It's not safe for him. It's time for her to go to the rehab facility and stay there for long-term care. What do we do? How do we pay for this? Again, they didn't have all that much, but they had a house that was held jointly. I want to move the house from the 2 of them to his name to get her on Medicaid. I can't do that with the power of attorney she has. And it's too late for her to do it. So what do? Guardianship. The guardianship takes about 3 months and costs about $15,000. Now, during those 3 months, he's paying privately for her care in the facility because we can't get her on Medicaid. Who knows how much an average month in a nursing home costs? 12, 11, 10, 12. Right now, Bergen County, it's about 14. Back then, it was about 11 or 12 when this story happened. Times 3 plus 15. All that money could have been saved had they done the power of attorney with the right lawyer. I have a lot of clients come in and say, I want to sue the lawyer who did the power of attorney. That's malpractice. It's not malpractice. Malpractice is deviating from a certain standard. It is not the norm to have a power of attorney that has all these extra things in there that we know are needed when somebody actually becomes disabled, but it's just not the norm. Mike Manna surveyed, just looked at all the documents we were getting for a certain amount of time, and he concluded that 97% of the power of attorneys we saw did not have the powers it needed. And again, we're in the information era. So many people suffer when they don't have this, but for some reason, nobody knows they need to have it. So I'm hoping I made that really loud and clear, and the horror story kind of sticks right here. Any questions? Go ahead.
Yeah, I have a question. So say you have something like this prepared in New Jersey and you end up retiring in California or Florida. Do the laws in different states honor where it's created or where it's being implemented?
No. So it's not invalid if you move, but every state has its own quirks, not in terms of drafting, but in terms of what's needed. So if somebody prepares a power of attorney in Florida, an elder law attorney in Florida may not have to include a gifting provision because that just might be the standard there. But if you try to go use it in Wisconsin, that they're going to require, for purposes of their laws, that you can do whatever you need to do based on their laws. So anytime you move, you should you don't necessarily have to redo your documents, but you want to take your document to an attorney, an elder law attorney in that state, and have them look it over. Make sure it's kosher for what they need to do.
I have a question about the example you just talked about. So the couple, you were trying to help the husband get the house in his name,
Mm-hmm.
and by doing that, that was going to allow her to qualify for Medicaid?
Mm-hmm.
I didn't know you could do that.
Are you free tomorrow night?
What time?
I'm giving a talk at an assisted living all about Medicaid rules, numbers, how that works. doing pretty good on time, so at the end we can talk about it a little bit too if there's interest here.
Excuse me, I have an additional question to that. How do you transfer, let's say, the deed to the husband if the wife is cognitively not all there? Is that legal?
That's the purpose of the power of attorney. You can act, it's a license to act on her behalf.
Okay,
So you sign the deed as the power of attorney.
So you said that there are, Michael, let's see, 97% that they did not include the proper powers. Are there specific powers that encompass all rules and regulations? So if you were to prepare a power for someone, you would encompass every power?
Mm-hmm. I put everything. I throw in the kitchen sink, and people tell me, why does it say here that you want to give my kids the right to make business decisions for me? I don't own a business. Or go to the DMV, I don't have a car. Well, you might. Well, I don't drive. Well, maybe one day somebody gets a van because that's handicap accessible. I throw in the kitchen sink, and it bothers people. It's funny. People are like, I don't need all this crap in here. This isn't what this is too much. I just want something simple. I'm like, well, you just want it to work. So as exhaustive as possible. And like for example, the DMV, the document isn't necessarily invalid if it says, I give you the right to transfer any of my assets. Doesn't mean you can't transfer title to a car, but when you go to the DMV, they're looking for the words right to transfer motor vehicle. So I just throw in a provision on anything we can think of. Any other questions about power of attorneys? Okay. We're going to shift gears here a little bit into wills. And the big P word that everybody's scared of, probate. Take your mind out of the gutter. All right. So a lot of people, I shouldn't say a lot of people, one of the biggest mistakes people often make is getting nervous that somebody's going to die with assets in their names. So grandma's on her deathbed. Grandma knows she's dying. Grandma says, get everyone in the family. I want to give you guys everything. I want to make it easy for you. I love you so much. Start signing things over to the kids. Good or bad?
Bad.
How many say good?
Depends on the value.
Tax consequences.
So I cannot tell you how many people come in that have a house that they're going to sell, and grandma gave it to them an hour before she died. And they don't realize the tax implication involved with that. Let's take a step back. Who knows what capital gain is? Okay, shout it out. Whoever's loud.
Difference between your sell price and what
Difference between sell price and what you bought it for. A lot of people in this neck of the woods bought their house for $32,000 in the 70s. And now it's worth $800,000. The difference there is called capital gain. And when you sell a property, you pay tax on that gain called capital gains tax. Now, if you're a U.S. citizen and you lived in it for at least 2 of the immediately preceding 5 years, it's your primary residence, you have a $250,000 forgiveness. And if it's 2 of you, that's $500,000. However, we're not talking about selling it right now. We're talking about you giving it to somebody. If grandma gives her house that she bought for $30,000 to the kids, and then the kids come in and say, we avoided probate. Grandma has no assets in her name. We're going to sell the house. And they have $630,000 of gain on that house. When they go to sell it, it's not there. They don't get their $250,000 exclusion. They might be paying $150,000, $100,000 of tax. Now, If grandma died with it in her name, she gets a step up in cost basis to her date of death value. So had grandma died with it in her name, and then grandkid got it, grandkid's cost basis is grandma's date of death value of $700, not what she bought it for $30. Again, I break the news to people and they want to fall out of their chair and they want to sue the real estate attorney who did this. But I say, you asked a real estate attorney, can you transfer title? And the real estate attorney did their job. You just didn't have the tax knowledge to do it. Another example where this can go awry. Grandma has 2 grandkids who are really, really, really helpful. But she has 4 kids and she intends for the 4 kids to inherit. But the one grandkid that happens to live next door is the one handling all her banking. And everyone's good with this and there's no issues. Grandma goes to the bank and says, you know, the lawyer said get a power of attorney. I should do that, right? The bank teller, anyone here in banking? The bank teller will probably say, you could just put her name on the account, make it really easy for her. Grandma puts granddaughter's name on the account to make it easy for her to sign checks and do what she needs. Maybe that account had $100,000 in it. Maybe, just to make the story a little more dramatic, grandma had a house that was sold before she died, and now this account has all of her money. Granddaughter thinks, oh, when grandma dies, her will says it's going to go to her 4 kids. I was just trying to be a good person and do the right thing and help grandma. Grandma dies with a will that says I give everything to 4 kids. But she has her granddaughter on the account as a joint owner. What happens? It all goes to the granddaughter. And the granddaughter is going to run away to Barbados. No, I'm just kidding. But even if granddaughter was a lovely, nice person who had every intention of honoring grandma's wishes, because grandma's going to haunt her from the grave and wants to split everything up 4 ways, she may not be able to. She might be sick. She may be on government benefits. She may have a kid who's in college and she's applying for financial aid for them. She can't make $1 million gift, even though she's trying to do the right thing. She might be in the middle of divorce proceedings and her spouse is going to be all over that. So although inheritance is not subject to equitable distribution, but the point is, just to avoid probate, we wanted to add people's names to things, and all we did was make a really simple process. We avoided something so simple, but we created a bad word. Not going to say it.
I have a question, and maybe you'll get to it later, but in that case, what other option does the granddaughter have so that she can write checks out for her grandmother or whatever without creating a joint account situation?
Who can answer that? Question is, what else could granddaughter have done to not become a joint owner?
Signing.
Power of attorney.
How do you sign a check as a power of attorney?
You're an authorized signer on the account. So if you have a document that says you're a power of attorney, you take it to the bank.
Authorized signer on the account as opposed to a joint.
Correct.
Okay.
And the checks will sometimes say Mary Smith, POA, granddaughter's name. That's fine. It doesn't give you any ownership interest. You don't get you don't get any tax consequence from any interest or dividends, and it allows the account to go through probate. Now, who thinks probate is a good thing? Who thinks it's a bad thing? Whoever thinks it's a bad thing is watching too much TV. Probate in some states is really difficult and really expensive. Notoriously Florida. I'm not licensed in Florida, but nobody uses wills there. They use revocable trusts to avoid the probate process. In New Jersey, while it's difficult for all sorts of other reasons, Probate is actually a very simple process. You don't need to, anyone probate somebody's will before? If you have a will that is self-proving, that what that means is they sign it in front of a notary, in front of witnesses. The witnesses witness you, and then you witness the witnesses witnessing you, and then it's notarized. That's called self-proving. And some eyes are rolling. That's okay. The original is present. No staples taken out of it. It's in blue ink. There's no question that this is not a blue inky ballpoint original document. It's not a photocopy. You simply go before a clerk at the surrogate's court. You pay a check of $100 or $200. You have a death certificate. Within 10 days, you are issued letters testamentary. That is it. So to avoid that, a lot of people do this big song and dance that creates a lot of problems. We don't need to worry about probate. Now, if you have out-of-state property, you may want to consider some other things to avoid probate, but there's a way and a mechanism to do that depending on the state that it's in. Any questions about that?
Just a question on the previous example, it's a granddaughter. Couldn't she take whatever funds, assets were available, gift them up to the aunts and uncles?
She can, but if she has a creditor after her, or if she's receiving benefits, she might make herself ineligible. It could be a fraudulent conveyance. In other words, if somebody's suing me and I take money and I give it to somebody, they can still go after it. If I have child support arrears, if I have judgments, it might collect all those on the way up, number one. Number two, depending on the amount, I'd have to file a gift tax return. And then on my death, depending on my exclusion, I may have to pay taxes. If I'm about to file for my kids' college financial aid and they say, you just had this money, you just gave it to somebody, she can say, just kidding, it wasn't really my money, it was a big mistake. I mean, she could try, but probably not going to work. So there's the answer is she can, but maybe not.
Right.
All right, so do not fear probate. Another problem, believe it or not, a child is an adult at 18. Now, I have 3 kids, they're young. The thought of them inheriting anything at 18, 20, 21, 25 scares me. Now, funny story, opposite end of it, I had a client who called and said her dad put things in trust for her till she was 65 and she was 60 and she thought this is ridiculous and she needs to get it done with, and the trustee can of course give it to her. I suspect she was in the middle of some divorce proceeding or something and there was a reason for that, but it's, how do I say this without getting on a soapbox and turning this into something else? I think, especially now, certain generations, it's not the same. I think even good kids who have a good work ethic, you throw money at them and you destroy that work ethic. I've seen some sad situations over the years. You don't want to leave things to obviously not minors, but you don't want to leave things to people until they're old enough to manage it. During COVID, I had a client who was in college. I think he was getting his master's program at some Ivy League school. Smart guy, straight ed, really, just a good head on his shoulders. Mom and dad both died during COVID. And he inherited about $2 million. And he dropped out of school to go find himself and thought he'd invested and lived off the dividends, and this is what his parents would have wanted him to do. We can't find him. It's been a couple years now, and people who may have some alcohol or drug issue, you throw money at them, they go off the rails. So be careful with leaving things to people. typically what our wills do, all our wills say, if I give everything to my kids, and if not my kids, then to my grandkids, even if my kids are old, if I'm giving it to grandkids, I put things in a trust until at least, I prefer 25. It's up to what you want, but until they're 25, and you have somebody else in the family manage it, if there is somebody else. Now, every now and then I get someone who says, my daughter's a financial advisor. Yeah, she's 21 years old, but I trust her more than I trust anyone else in the family to govern her money. Fine. That's a different situation. But, and if you don't have anyone, that's one thing. But I would prefer, for most people, you put it in a trust. Now, the trustee can be anyone you want, and the trustee has the discretion to give it all to them early and terminate. But at least it gives us some authority to not have to give it to the kids if the kids want it. Questions about that? Go ahead.
I think you can also put provisions in about certain behaviors that if they're not living up to certain standards, like if they, have some, let's say, drug-related issue or something, you can put those provisions in as well.
He said, I believe you can also put in some certain provisions in terms of, their behavior. If they're in school, now that's true. However, there was a case where very well-meaning mom said, I give this to my son, but only if he's going to marry a nice Jewish lady. And the court said that's a restriction on his freedom. So, I wouldn't want to push it with that. It gets a little, you're testing the waters, and it's so. But that's true. I mean, drug and alcohol, I prefer to say we give them nothing and then we tell the trustee, hey, listen. And what I have with my personal stuff is, aside from my will, I have a letter that goes with it that says to my brother-in-law, listen, if it has to do with education and study abroad, I don't care what you give them. If they're spending it on clothes, they can earn it themselves. I don't really care. So you can give some guidance, but I don't want to make it a legal obligation. I trust him, pun intended, to manage the trustee at his discretion.
So I have a question. I was going to ask you about the magic age, the answer is 20, 25 or whatever. But my question is, when the money goes into a trust, I think we have it set up that way, it goes into a trust. And and we have a trustee. So if we were to drop dead and all of our assets go to the trustee, or do they stay with the attorney? And so the trustee has to, so in other words, is there some financial burden that the trustee is now, even if we're paying for it, the trustee now has to deal with the attorney on a regular basis to get the assets?
I'm glad you asked that. A lot of people, this came up. Someone thought that the trust was like a box in my office that I keep or something. All the trust means, it's like a custodial account. So the executor goes to the clerk and says, I'm the executor, I'm going to execute the will, and I'm going to disperse. And I'm going to give it to these 4 people. But this person, a trust is going to be created for them. So I also need to be appointed as trustee, or if it's somebody else, as trustee for that person's trust. All they do is reach out to the financial institution and say, here's an EIN number, a federal ID number, which any lawyer or accountant can get, and just change the ownership on the account, almost like a custodial account. It's completely at their hands. They don't need the attorney's not involved at all. I'm glad you asked that, because it's, if you haven't experienced the trust, it's like, what's this? What is this thing? Where do I find it?
So what if you have investment property that is an LLC, and would that also potentially go into trust, or should it be its own real estate trust?
So we're talking about testamentary trusts right now. Trusts in a will that are for certain beneficiaries if the need arises. That trust can be the owner of anything. If there's an LLC that's getting passed, then it can be dispersed, right? It can be in percentages owned by the different trusts, yes.
Would you ever, what circumstances would you recommend a real estate trust be set up for an investment property?
So you're talking about living trusts. So hold that thought.
Okay.
Hopefully we'll get to that. It's the next thing on here. All right. So revocable trusts. Who has heard of revocable trusts? Who has a revocable trust? Anyone in this room have one? Okay. revocable trusts hurt me because I do the Medicaid applications in our office. And I cannot tell you how many times family members come in with a nice leather-bound binder and they say, you know, Mom and Dad did a really good job. They planned for this. They knew this was coming. They did good. I know their assets are protected. Here you go. Do the application for us. And I open the binder, and the first word is revocable. And I say, sorry, this is all part of the pot. And they say, what do you mean? I say, well, Mom and Dad still own it. And they say, well, so what does the trust do? I say, I don't know. They say, what do you mean? They spent $8,000 setting up these trusts. And I say, well, you avoid probate. That's all a revocable trust does. But you guys are now experts after having listened to this class, and you now know that revocable trusts do not protect your assets because you still have a right to get it. And the state, no government agency is going to give you benefits for a trust that you still have control of. They're going to say, well, use it. You have those assets. They're countable. They're yours. Now, I'm just going to draw something up here for a sec. There are different kinds of trusts, and I don't want to lose you guys. So in the world of trusts, we have inter vivos. Who knows what that means? Living. It's living trusts. Oops. And we have testamentary trusts. Who's going to explain this to me? No? Go for it.
Testamentary is created when you pass. Intervivos is when you're living.
Very good. Very good. So testamentary trusts are trusts created via your will. They are the trusts for my kids. I'm not setting them up now. I'm not going to pay to maintain a trust right now. It's my money. I'm not planning on going anywhere. God willing, I'm good. However, if I pass away and at the time my kids are under a certain age, this will hatch via my will. If I don't die, or if I die without the need or the circumstance being triggered, this doesn't ever come to life. Inter vivos are living trusts. Those are trusts that are created now while I am alive. And there are two different kinds. It's one, I shouldn't say two different kinds. That trust can either be a revocable trust that I maintain all rights to, or an irrevocable trust that I lose rights to. Now, there is a huge difference between these two in terms of what they do for us. Like I said, a revocable trust does nothing. The IRS, the state, the VA, all consider this part of you because you still maintain control over it. I've done them before. Who do I do them for? Number one, if you have out-of-state property and we are worried about probate in that state. Florida's a big one. Everyone's doing these. Nobody's doing wills. I've done them also for people who needed to keep things super, super, super secret. What do I mean by that? An NFL player who has a child, I got to use the right term now, you can't say illegitimate child, a child out of wedlock, has a child that they don't want the world to know about. If we put it in here and make some bequest for that person never comes to light and it's newsworthy, it's going to be all over the papers. On the other hand, if it's just in the will, this person gives so-and-so this much money, the will, when the person dies, becomes a public record. Now, most of us don't really care if the world finds out that we gave things to our kids. It doesn't say what those things are per se. There's no account numbers. There's no confidential info. It just says, but if you have a super secret boyfriend or girlfriend or somebody you don't want the world to know about and you're leaving things to, you may want to consider a revocable trust. Besides that, this does not do us any good. And like I said, it breaks my heart because people come in thinking they did the right thing, they tried to do the right thing, but it gave them no benefit. Irrevocable trusts are trusts where you give up control of whatever you're putting in there. That's a big pill for people to swallow. You have to be okay giving presumably your children or your siblings or whoever, giving them your wallet and saying, hold this. It's not mine anymore. I'm giving it to you. They have to be okay with the fact that that person can run away with it. They have to really trust that person. However, if they do, some people say, that's no problem. My kids are already paying my bills and managing my stuff anyway. I have no control of it now. I mean, I do, but they do everything now anyway. And they're comfortable with irrevocable trusts. If you put assets into irrevocable trusts early enough, 3 years before you need care, the VA, 5 years before you need care for Medicaid, whatever's in here is completely protected. Now back to your question. You said, can I put an LLC into a trust right now? Yes. If you put it into a revocable trust, it's not going to, I don't know what the circumstances, but I don't think, if you put it into an irrevocable trust, you give up control of it.
So they can, again, the person responsible can sell that asset then
Correct.
and distribute as they see as they feel.
Correct. Any questions about that?
And it's a 5-year look back.
For Medicaid, 3 for the VA. All right. Last big problem. It's misplacing original documents. And again, I will tell you a horror story to make sure this stays in the front of your minds. And it usually works because people come in and say, oh, I attended your class 10 years ago and I remember, yada, yada. All right. So if an original will is not found on your death, it is presumed to be destroyed and you did not want it anymore. You have a horror story for us, sir. You seem like you have felt this before.
Yes, I did.
Do you want to share or not really?
No, there's no problem in not sharing, but just to hear about it after a lot. It's funny because I talked and met Michael Manna because of this, and I never forgot him, how good he was.
Oh,
My aunt told me, help me, when I die, go to this bank. I'm going to give you a key. My original will be in this bank, in Florida, Hollywood, Florida. She passed away. I immediately went down to see what going to transfer. There was no will. But then she had given me a copy of what she said was in the bank. And the copy, unfairly to me, shifted money where I never expected it to go. Mm. She gave her sisters all the money and gave none of the kids any money under the supposition that the parents would then take the money and give it to them or share. It was a boggle. She had a preferred grandnephew, and he got tons of money and the others didn't get anything. And I was having a fit because if I have to tell everybody this, short the story to what you were saying. The attorney said to me when I got one, little lady, terrific lady, she said, I got some bad news for you. This is an invalid situation. No original will, but there's copies all over, doesn't matter. No individual will, it is not the intent possibly of that person to honor that will.
Mm-hmm.
And that is the end of that. Unbelievable.
I mean, it's thank you for sharing that. It happens all the time. There is not a week that goes by without a family member coming in and saying, so and so died. We went to go look for the document. It's not there. What do we do? Now, as much as we can think it's really frustrating, it makes sense, because if I draft a will one day that says I leave everything to you, and I give you a copy of it, and I keep the original, and then you and I have a falling out, and I go do another will, maybe just because you had a copy, it wasn't my intention that it gets probated. Now, this is particularly problematic in this green paperless era. I can't tell you, even after explaining this to people during our meetings, we do the signing, and they'll tell my secretary, you know, can you shred it and just send it to me on a flash drive or a PDF or email it to me? It doesn't work. Now, it's a rebuttable presumption, but it is very hard to rebut. So I'll give you an example. One year, I want to say about 5 or 6 years ago, there was this cute little old lady who lived in Fairlawn, who was 91 years old and was worth about $6 million. She was never married, had no kids, which is probably why she was worth $6 million. And she updated her will regularly. She had a neighbor of 26 years that took good care of her, who she intended to give her some portion. She had a first cousin once removed in Florida who was her closest living relative, who she wanted her to get some chunk. And then the other 60% was going to all these charities. And every year or two, she would call us and update her will and say, oh, the Boy Scouts of America are in the newspaper. I need to reduce their percentage. Or Don Bosco, I'm going to give the Franciscan. And she would change her will regularly. One day she called and she said, I want to give 5% instead of Don Bosco Prep, I want to put it into a charity or a scholarship fund that they have within it. Can you do this for me? By the way, I'm going in for surgery tomorrow. We didn't have time that day. I said, I can't make this happen today. It was like 3 o'clock in the afternoon. I was like, I can't make this happen today. But I wish you the best in your surgery. When you get out and go to rehab, God willing, call me. I will meet you there. We'll get this changed for you. She says, okay, no problem. I'm putting it back where it was. She had a blue chair in her living room with a filing cabinet next to it. And she would tell everybody, it's in the cabinet next to my chair, bottom drawer, halfway through the back. I'm putting it back where it was. And just remember, we're going to update this. I said, got it. Well, we got a call about a week later from her cousin and her neighbor. You guys all know where the story's going. Unfortunately, she did not make it through the surgery. They say, what do we do now? I say, you need to go find the original will, come to our office, or I think we told them, take it, get the death certificate, which takes 10 days, go to the surrogate, get it probated, bring us letters testamentary, and we're going to help you figure out what to do next. Because they had to deal with the attorney general and all that because of the charities. They said, okay, no problem. Can we start cleaning out the house? There's food in the fridge. What do we, like, we can't just leave it out. What do we do? We're here from Florida because we were here dealing with the funeral arrangements. Yes, you can. She had these 2 cute little Polish ladies who were her cleaning ladies or housekeepers who said, we're going to help you clean. Oh, and Fairlawn's recycling day is Tuesday, and she had a lot of paper. You know where this story's going. They take all the paper, they put it out for recycling. They realized that in the middle of her newspaper clippings that nobody wanted was her will, and it went out for recycling. Now, they told me they threw it out by accident. Talk about a rebuttable presumption. The courts say if the original's not found, it's presumed to be destroyed. You can rebut that. Number one, I had a conversation with her. I knew she didn't intend to destroy it. Number two, they threw it out. Amazing. So now, not so amazing, but kind of amazing, we take the will to the, we have to go in now by order to show cause in a complaint. We have to file something with the courts. We can't go through the self-proving easy probate. We got to deal with the court. Go to the court, all these affidavits, anyway. Prepare a signed statement for the two little ladies to say they threw it out. They're like, wait a minute, this is going to the courts? We work here illegally. Peace out. We don't hear from them again. They disappear on us. Although the courts aren't going to talk to the immigrant USCIS. It was INS back. I mean, they're not. That's not their cup of tea. But I'm not going to give them any sort of guarantee that they're not going to, after making a public statement that their work. Anyway, they were nowhere. They went MIA. Luckily, I still had the conversation not only with her but with them, so I was able to, as a totally disinterested person, provide a sworn affidavit to the court. The process was a nightmare because had she not had a will, the people that would have inherited, if you don't have a will, New Jersey gives you a will. It's called the intestate statute. Basically, if you're never married and you have no children, no descendants, it goes up. Parents, she was 91, her parents were 6 feet under. Then it goes to the descendants of your parents in equal shares. Her siblings had mostly passed away. There were a lot of them, like 8 or 9. Each share, so if she had 8 siblings, it goes an eighth each. And if whoever died, that eighth goes down the line to their children and their children. And we had to notice all of the people who would have inherited had this will not been accepted, because they have a right to contest it in court. Now, half of these people had no idea who she was. And that was a lot of money. Some of them knew who she was, hadn't talked to her in forever. We had to find them. We had to hire a genealogist. They came back, the courts came back and said we didn't do a diligent enough search. They want us to push harder because we made a publication in a newspaper to one of the kids was a runaway last seen in Nevada in the 80s. And the court said that the publication we did in the Nevada newspaper was regional and we should be more widespread because she may have relocated. $26,000 later, we got the copy admitted into probate. Only because I happened to talk to the woman the day before. What are the chances? The reason I'm telling you the story is to help you remember that the original is the only thing that matters. And I cannot tell you how many people continue to go set up all this fancy stuff, go home, shove it somewhere, don't tell anyone how to find the original. And, maybe before you die, you move out of your house, you need care, you go to an assisted living, you downsize, you go to a 1-floor ranch. Maybe at that point, nobody's going through all the tchotchkes that you have, and people are just getting rid of stuff. And we just did it. We're in the middle of a case right now where we were trying to get a copy admitted, and there were 2 versions, and everyone's feuding and fighting, and it's a big, long drawn-out court case. And 1.5 years into the case, somebody randomly finds it in a shoebox that they thought was a bunch of old shoes when the court finally gave someone the right to clean out the house because there was no will. So the original is the only thing that matters. I know it's a paperless world. I mean, even our copy, I'm having a problem with our copier people. I thought I was upgrading our office industrial copier. They gave me one with lower capacity. And I'm like, what is this? It was supposed to be an upgrade. They said, well, you're not supposed to be printing that much anymore. You're supposed to be scanning. I'm like, that's not going to work in our office. We go through thousands of reams of paper. Anyway, point is, this is an area where you will never go paperless. This document is a must. You have to have it original in your possession. Go ahead. 1, 2, 3. Good question. Is the recommendation for the lawyer to keep the original? The last time I taught this class here, I said this problem I have about keeping the originals, and somebody told their daughter, and their daughter wrote to us and said, I'm in law school and I want to do an internship and come help you with this problem, and she did. Until then, we have a fireproof cabinet with wills that we have from probably the 70s and 80s with thousands of them. People who I'm sure have died, nobody has come looking for the wills. So I don't like to keep the originals. If I am the executor, I will. If a person is in a home and has no good place to put it, no safety deposit box, doesn't trust anyone, and they ask me to, I will. But I don't like to. Number one, your executors may not know to come to us. Number two, I don't want them to have to feel like they have to come to us. With all due respect to other attorneys, because it is a problem they might be trying to avoid, is having clients lose their stuff. I think attorneys sometimes like when the family has to come back to them. The reality is you don't need an attorney to probate your will. I don't want anyone to feel obligated to contact us, so I don't like to hold them, but we have held them in the past. My preference is a fireproof box off Amazon that's $30 in your house, under some towels in a bathroom closet, and you tell people where to get it. Especially if you need it, the medical power of attorney or the living will on a weekend or a holiday or.
So I was talking to our attorney and also my parents' attorney recently about what happens with the will if he dies, because he's a small, just him and his partner, and he's older than us, and so if he were to die first, he has to name somebody, and I was like, I don't know this person, so I was like, what do we do? So I haven't really talked to him about it, but that's one of the things I thought about. I didn't know if I had a right to say, hey, I want my original, I'll keep it in.
Yeah, no, you do.
Okay.
It's your property. And that's the other thing. Attorneys die too. I mean, just in the past 3 years in Ridgewood, 2 of the very prominent attorneys who drafted wills both they passed away, and now the courts are starting to do this thing where you assign somebody in advance to take over your practice, but it doesn't necessarily mean they're going to have access to your physical office.
So if you keep your will in a safety deposit box, so you add your child's name to it, so they have access to the box after you die.
Correct.
So you have to make sure you have that child's name on it to access, or somebody's name on it to access the original will.
You should. If you don't, it's not the end of the world. The question is, if I put a document in a bank safety deposit box, who has a right to get into it without having the will and being the executor? Most banks, I think all banks, but I'll say most, will allow a supervised visit into a safety deposit box to look for a will when somebody has passed away. So if they're not on the account, it's not on the box, not the end of the world, but it's probably good practice to give them access.
Just a quick point on safety deposit box. A lot of banks are doing away with safety deposit boxes. I've been trying to find one. A lot of them say they don't have any or they're not doing it anymore.
Really?
Yes.
I know there was a while where people couldn't find them. Like, for example, the Ridgewood banks, like they were full, they didn't have. But I don't even think you need a safety deposit box in the bank. I say a fireproof box in your house, because if it gets stolen and someone's going to run with it, I mean, it's paper. You can always re-sign it as long as you're competent. And I'm assuming if you're living at home, you're still competent.
I was going to say, I'm just saying, it's like 100 pounds, it's fireproof. You don't have to go to the bank to, see the document.
Yeah.
Much more practical.
Yeah. Fireproof, waterproof.
Is it only one original, or can there be more than one original?
One. Technically, everyone revokes the prior one.
So if I go to you, I can't get 2 originals, it's just one.
I've seen some attorneys do it, but you're not supposed to. Any questions about original documents? Okay, we got 15 minutes. Any questions about anything at all?
Grandma and the granddaughter. Would it make sense for her to put the house in the irrevocable trust?
It depends on the circumstance. So the question is, back to grandma and the granddaughter, should she have done an irrevocable trust? So it depends. An irrevocable trust is not for everyone. what is the purpose of it is really the question. Typically, most of my clients are doing them. Number one, they have somebody they trust. In Grandma's case, she did. She put her not only as a power of attorney, put her on as a joint owner. Let's say Grandma had long-term care insurance that was going to pay for all of her care forever, or Grandma was terminally ill and wasn't going to make it. I don't know why she would necessarily need it. It may not. An irrevocable trust, it's the purpose of it is to protect the assets from costs of long-term care. If you don't need that, you don't just do it for no reason. It's not cheap to set up, and it's it's a big step. You're essentially disclaiming and relinquishing your estate in advance.
You just said when you were speaking earlier that it's a bitter pill to swallow, but it really is to let go and let someone or people in the trust totally take over. You mentioned earlier about a dividend, whatever it is,
Yeah,
they could sell.
absolutely.
You could be homeless.
Does that become the asset of the person?
Question is, does it become the asset of the person? Not really, no. It's almost like, for any Catholics in the room, I relate it to purgatory. It's not theirs, it's not yours anymore, but it's not theirs yet. It's in this bubble. Now, they're the beneficiaries of the bubble when the trust ends. And they shouldn't end it until you die. But until then, they manage at their control and discretion. You really do have to trust them. Sometimes people say, I'm only going to do it if two people can act at the same time. There's a check and balance system. That's very common when there's, it's second marriage. Each person's got their own husband and wife. Each one's got their own tribe. We get one from each tribe. They really have to get in cahoots to do something wrong.
In that scenario where, again, an irrevocable trust is set up, and ultimately, let's say I pass, the person who's the trustee, is it still in an irrevocable trust forever? I mean, do they have the right to break
So the
it?
question is, what happens when the grantor, the person giving and establishing the trust, is what happens when they die? Well, the trust stays in place, and then whenever the trustee is ready to terminate, they terminate. We typically tell them to terminate as soon as possible after the person dies.
And as far as the cost basis of, let's say, that asset, there's no step up per se, is there?
Good question. The question is, what about the cost basis? Do we get a step up if it's in a trust? The answer is yes, no, maybe, sometimes. We have created trusts where you do get a step up. I don't use them for everyone. Typically, my average client will have 2 or 3 different trusts. One of them gets a step up, one of them doesn't. One of them also gives you the 250 exclusion if you still sell the house during your life. What asset goes where, I cherry pick based on where the situation, what the asset is. If the person's estate exceeds the estate threshold and it's all cash, I'm going to dump it into a trust with no step up because we don't need it, but it'll get it out of the person's taxable estate also. If the person's below the estate tax threshold, I'll pull it in and give them a step up. And sometimes we do a mix of each. When we are hired to do a trust, we do an asset analysis, figure out each holding, the cost basis, and we cherry pick. Well, if we had to pay state tax on it, it would be this much. If we had to pay gift tax, it would be this much. And let's figure out which one to use.
The right attorney.
Sorry?
Thus picking the right attorney is important.
Yes.
Timing of the irrevocable trust, like, is there like a average age that you do that, or?
Good question. Average age of somebody doing an irrevocable trust. I would say the average age is probably 70. But I've done it for people who were in their 50s who, and the other question is average amount of money, like what's worthwhile. And I think all that really depends on the family circumstance. I have had a client who was 51 years old who had $80,000 in the bank. And he said, I can't believe I made this money. I came to the country with $2 in my pocket. I need to set up a trust for this. And the kids were paying for dad's expenses. But dad really just wanted to give them that $80,000, and he set it up. I had no problems with it, although his kids were young, because his kids were the ones supporting him. On the other hand, it really depends on what people typically do this when they have someone to leave their assets to, besides a spouse. So most of the time, not always, because we sometimes do it for other reasons, but most of the time they have either children or nieces or nephews that they want to benefit from this. And I would want them, I feel better when they're at least 25, 30. I feel like who you are at that point in your life is pretty much who you're going to be. But I've had cases where the child was in their 50s and mom was 80s or 90s, and the children they don't seem like, they can handle it, and I don't do it. So, not everyone's the same. It really depends.
When there's a will obsolete and you need a trust,
Say that again.
let's say I have a will now. Do I need a trust? What's the reason I would need a trust over a will?
Well, I can't answer that without asking you about your assets, which I'm not going to do in front of everyone.
Well, it depends on how big your estate is.
Well, it depends on a few things. Number one, how's your health? Number two, what's your life expectancy? Number three, what's your income? If you're living off of your income and you're not using your savings, why keep it exposed? But if your assets are all retirement accounts, I can't touch that because I'm going to trigger a huge tax. So it really depends on a lot of circumstances. And just so typically what we do in our office is free consultations. So we can take our time figuring out, your situation. You take your time asking us. At the end of that, we quote you a fee and give you a proposal based on what we recommend to you. It may be nothing. You might be perfectly set. Any other questions? One more.
You mentioned earlier about the probate. We can just go, or we can go with attorney. When is it necessary for attorney to go together for probate?
Well, if you have a good will and it's the original, you don't need to go before a judge. If you have, when is it necessary? So the question is, when is it necessary to get the court's involvement and get an attorney for the probate process? If you have a will that's written on, that can invalidate it. If the staples are taken out, we've had cases where we had to get paper experts to prove the paper came from the same ream because people were accused of swapping pages. If it's not the original, like we said, if the will is problematic for some reason, if it names people who have all passed, or if there's an error with it, those are the more common reasons why a will would not work. All right. Well, thank you all for attending and for listening. If anyone has any questions, you can certainly email me or call me, and we'll go from there. Thank you.
Your firm doesn't